this is how it went.
Like, come home. Please come home. I miss you. The kids miss you. I don't know what's going on lately. This little sojourn of yours. I understand you want to see the world. I understand you want to do things outside of, all the other things that you do, but we need you.
He does. He really does. Seriously, he's been at my house crying nonstop. Please come back. I can't kiss him anymore. I can't pretend to be you anymore. I just can't. I'm trying, but it's just so...
His basement is so scary.
It is.
And I
Please
don't have anyone to hold me at night.
Well, friends, here we are. We're finally at a point where the Wayfair parties are getting ready to file an appeal, and everything just changed. Let's talk about it. So on Friday, the New York Times filed this motion. They're asking the court to finalize their judgment, declare them the winner. And by doing so, they've asked the court to start the clock so that Wayfair can file an appeal against them. In response to that motion, Wayfair has now hired one of the leading appellate attorneys in the country, Alexandra Shapiro. And this new firm appears to be in place as Wayfair parties prepare to appeal Judge Louis Lyman's dismissal of the New York Times, Blake Lively, Ryan Reynolds, and Leslie Sloan. So on Friday, in a motion, the New York Times were seeking an entry of judgment under Rule 54.54B. What this ruling does is it allows the court to close the case against the New York Times on a very active docket that continues to post updates on the daily, with over 700, close to 800 docket entries. The New York Times was dismissed from the case in June, but because the case with Lively continues to be ongoing, the case is not over, and Wayfair cannot appeal the decision of the dismissal against Lively, Reynolds, Sloan, or the New York Times. And now the New York Times wants out because they want to allow Mr. Baldoni and Wayfair the opportunity to appeal if they're going to, and they've even cited a few areas in which they believe they might be vulnerable to appeal. In their letter, it says, because this case remains active and because final judgment is generally only entered after the rights and liabilities of all parties to the action have been adjudicated, the court has not yet entered judgment in favor of the Times against the Wayfair parties. Under Federal Rule of Civil Procedure 54B, a court can enter judgment in an action involving multiple parties when the claims against one party have been finally decided and there is no just reason for delay. They are a third-party news organization. They are situated from all of the other remaining defendants. The claims against the Times have all been dismissed with no further leave to amend, and entering a judgment would expedite resolution of the case between the parties and the Times by the Wayfair parties, allowing them the immediate right to appeal and ensuring a prompt resolution of this case, aligning with the New York court's direction that defamation actions should be dismissed at the earliest possible stage due to the real risk of infringement on First Amendment rights. They say that this decision will not affect the rights of the remaining defendants, and they want the court to enter a judgment in favor of the Times against Wayfair. What I find really interesting about this is that they have really changed their position. They were so adamant that their story was about sexual harassment that occurred on the set and this sinister campaign that was undertaken by Baldoni to ruin the reputation of Blake Lively. They were adamant that it was about sexual harassment and it wasn't about creative differences. But now they're framing it as though they're admitting, oh, no, there was creative differences, which underscores Blake's point that creative differences had nothing to do with it. They write, as the article reported, the filming, production, and post-production of the movie were plagued with controversy about the movie's contents, intimacy scenes, and its marketing, among other things. The article explained that Lively had alleged that Baldoni and others engaged in inappropriate on-set behavior, and then, when they feared that her allegations would be made public, they created a smear campaign to tarnish her reputation. But in the very beginning, this is what they say. The actors vehemently disagreed about creative control of the movie. If creative control is not a factor in this case, then it shouldn't be an issue addressed by New York Times, right? They believe now that it was about creative differences. So it seems like a pivot a little bit. They admit that the article explicitly relied on and cited the CRD complaint as well as text messages, emails, and other documents included. So here they're admitting they went outside of the CRD to form their reporting. They note to the judge that there are actual grounds here that if the Wayfair parties wanted to appeal, they could. So they tell the judge that in determining whether the Wayfair parties adequately pled a defamation or false light claim against the Time, an appellate court would be required to determine whether the statements in the article were privileged as fair report of the CRD complaint and whether those responsible for the article's publication acted with actual malice, subjective knowledge that the article's contents were false, or a high degree of awareness of probable falsity. These questions are entirely unique to the Times. The fair report defense requires comparing the published article to the filed CRD complaint. The actual malice is a subjective state of mind that must be pled and proven as to each defendant. Thus, the conduct of other defendants and the fact that the Wayfair parties also brought defamation claims against those defendants have no bearing on an appellate court's review of the defamation and false light claims against the Times. So, really, what they're saying is that there is a dispute here about whether or not the CRD report that wasn't a court record qualifies under fair report, right? So there is a privilege that's afforded to journalists called the fair report privilege. And it allows journalists to report on matters of the government and government documents that are filed before a court within a governmental institution if they are public records. So it could be an official proceeding like a case, a lawsuit. It could be governmental documents, statements of public officials that are accessible to the public. It could also be matters of public concern reported but must be of public interest. And in this case, there will be a dispute about whether or not this was actually a public record, along with was it portrayed accurately as a CRD complaint rather than a lawsuit. And one of the arguments that Wayfair has made consistently is that the California's Civil Rights Department and this organization where you file this document, these are not automatically public records. So when you file a CRD complaint, whether it's for discrimination, harassment, or retaliation, the complaint itself is considered confidential during the agency's investigation, and it's not something the general public can freely look up like a court case. The respondent is the employer and landlord or entity that's being accused. They receive a copy of the complaint once it's accepted, so they know what the allegations are. Full complaints are not published online, and they don't release aggregate data and may disclose limited information in response to a Public Records Act request. So if you were to go to the CRD and request a copy of this complaint that she filed, they do not send you the attached 94-page document where she claims all of these allegations occurred. And that's where all the text messages are, right? And what they send is a copy of the form, a letter from the CRD stating that she was waiving her investigation and that she was given a right to sue. That's all they send you. They do not send you that large CRD document that looks like a lawsuit but wasn't a lawsuit and is not required to file with the CRD. In fact, that document, it was performative. She didn't need it for the CRD to file the request for a claim. One of Wayfair's arguments this entire time has been that this was actually not a public record. Additionally, it was not a lawsuit. And if you were to go and try to find this on the New York Times, they list it as a complaint. It's viewed as a complaint. It says on the SEO, when you search for it, it says, read Blake Lively's complaint against Wayfair Studios. The implication here is that the complaint is a legal document, okay? And then when you open it, it looks like it's an actual lawsuit. It has all of the headers that make it seem like it's been filed in court. So it is masquerading as a lawsuit. And on the page, it says Blake Lively versus Wayfair Studios LLC, implying again that this is a lawsuit. It also has Blake listed as a plaintiff and as Wayfair being a defendant. It also claims that it is a complaint for damages, okay? And it lists 10 damages. But if you go through this complaint, and what the lawyers for Jed Wallace pointed out in the state of Texas is that this actually isn't a lawsuit. It's a draft complaint because at the very end of this, those damages that are cited at the beginning don't exist at the end. There is no prayer for relief as far as what they are seeking, and then it is not signed. So this is not a legal document. It's a draft document, but they posted it as though it's a complaint, as though this is a lawsuit. And Blake framed it looking like a lawsuit. And if you weren't paying attention, it would have looked like a lawsuit. And then you wouldn't really know until the very end when you're like, oh, wait, then it just stops before they ever list any of the damages on page 62. And what Wayfair tried to argue about why they don't get fair port privilege is that in the state of New York, their fair port privilege is very broad, and it allows individuals and reporters to report on investigational proceedings within a government institution, even if it's confidential. Okay. In California, the CRD is confidential. So she could go and take her California CRD, which is confidential, give it to someone in New York. They get to report on it because they're in New York, even though it's not a public record. Now, what they have tried to argue, and the judge didn't agree with them on, was that this was actually not a public record. And the New York Times framed this as though it was a lawsuit. The headline itself says, read Blake Lively's complaint against Wayfair Studios. To the public, that clearly suggests a filed lawsuit. But what they had was only a draft complaint. The fair report privilege protects reporting on actual proceedings. If it wasn't filed in court, then it's not a part of a public proceeding. By labeling it as a complaint, they created the impression of a court record that never existed, and that's a mischaracterization. And mischaracterization can strip away privilege, and it opens the door to liability if the reporting was false or misleading. So at best, this is sloppy, right? At worst, it's reckless or malicious because it's suggesting a legal proceeding existed when it did not. And the fact that they tell the court, listen, if you, in the off chance that this gets overturned, we don't want discovery to be lingering on years later when memories fade. We want to get into discovery now in the off chance this gets overturned. But we know that your ruling was amazing. And at the heart of this is a meritless case. But they also, by doing this, are acknowledging that they have weaknesses here. So what their weaknesses are is they've published emails and texts that are not part of a public record. They mischaracterized an attachment draft as a complaint and underlying the CRD submission as confidential under California law. So those aren't actually meritless. First Amendments don't override factual misrepresentation. And the fact that they are now hiring attorneys. So this morning, after this was filed on Friday, Wayfair hired a law firm that specializes in civil and criminal litigation. But most importantly, they've hired an attorney named Alexandra Shapiro, who is a top appellate lawyer in the United States. This is a woman that was a clerk for Ruth Bader Ginsburg on the Supreme Court. She worked as a U.S. attorney and federal prosecutor, and now she's regarded as one of the top appellate lawyers in the United States. So this is someone who specializes in appeals, and they aren't brought in to monitor a case. it means most likely that they're going to directly challenge the dismissal of their claims against the Times, and they likely believe they have strong grounds. They're going to likely claim that the Times used non-public text and emails outside an official proceeding. They mislabeled an attachment draft as a complaint. They are going to likely bring up that the CRD filings are confidential, and so there's no public record basis. They might go back to choice of law, California confidentiality versus New York privilege, the scope of what fair report privilege covers, and the mischaracterization. So by having these appellate attorneys come in now, they're obviously going to, in my opinion, help them strategize about how they're going to respond to the New York Times. And they have one of two options. They can either fight the Times and say that, no, you need to wait until the end, and we're not going to let this get derailed, because if the Second Circuit agrees with the Times, that could also impact their ability to appeal the case against Lively. And it could also reaffirm to Lively, see, this was meritless and baseless. But on the flip side is that if it reverses the decision, it also will weaken the case against Lively, which would then weaken all of these sanctions demands she's making. And all of this explains why she is so desperate for the judge to declare her the winner, because she knows there's a risk here for appeal. And I have no doubt that she knew that the Times was going to be filing this for judgment, which now makes sense why she's, oh, I need money. You must declare me the winner. The same week that the Times is like, you must let us out so we can be appealed. I have no doubt they're going to appeal this. And they may not even fight them on that. They'll say, yep, you know what, judge, you should allow them to get their final judgment. We're going to appeal. And because the Times has presented a story where their claims are vastly different than the claims against Lively, they're going to say, yeah, there's no burden here. We're going to go there. And oftentimes, appeals courts don't like dispositive dismissals early before discovery without being able to prove the case. And in recent times, Sarah Palin had her case overturned on appeal. She lost at trial, but they still allowed her to go to trial to try to prove malice. And in the past, they have overturned cases where the Times has relied on anonymous sources, materials that are not public, and mischaracterizations of documents. They're not afraid to overturn dismissals if privilege is stretched too far and if actual malice allegations are plausible. Now, the judge Lyman said there's no actual malice plausible here, but Wayfair will argue, no, there is, and here's why. So the Times are hard to sue, but they're not untouchable. And their reliance on those text messages and emails, which the judge ignored, and their reliance on a CRD draft complaint, positioning it as a court record, makes them vulnerable. And I think they know that. So I see this going to appeal. I don't know if it's going to happen today, if they're going to not fight it. They're bringing in an appellate attorney now, which tells me that if they need to, they're ready to go to appeal. This is also a signal to Judge Lyman that, listen, you've been handing her a lot of wins here, and you've been giving her a lot of slack and rope, and you've been overturning everything that we try to do. And we have grounds for an appeal, and we are going to appeal, and we will go to the appeals court. And judges hate being appealed. And so in a way, it's also strategic because they're bringing in this lawyer at the same time Blake is asking for this financial windfall for him to declare that she gets sanctions based upon a law he didn't even use for his motion to dismiss, on a law that has no case history. Like, there's no case precedent for how this treble damages have ever been awarded. It's never been ruled on. It's a brand new law. And so they're telling the judge, like, you need to think smart about how you're going to make decisions now, because we're not going to just sit back anymore. We have an appeals team now. So it's strategic, it's smart, and I'm eager to see what the next steps are for them. And, all I care about is fairness in this court. And it's been really hard to watch the judge twist laws outside of what is precedent and to ignore factual and legal arguments as though they are inconsequential and meritless, and also to try to discount and say that they can't prove malice, which is impossible to say. You can prove malice. That's why you go through discovery. So we'll see. Let me know what your thoughts are. It's a power play and it's a good one. Tell me in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed and click the bell so you never miss a video. Thanks so much for watching. Bye, besties.